The first violent crime we're going to talk about is rape. Rape is the taking of sexual intimacy with an unwilling person by force or without consent. Historically, rape was regarded as an offense that could be committed only against a woman not married to the defendant. Husbands could rape their wives. And it was seen as a crime of violence against her and as a property crime against her husband or her father. Today, the law recognizes that rape can be committed against females and males, and it's viewed both as a crime of violence and as violating an individual's basic right to decide with whom to have sex. Today's laws eliminated marital rape exception, creating rape shield protections, and eliminated the need for prosecutors to have corroborating evidence to the victim's testimony, i.e. allowing his or her word to stand. And there's also been extensions of laws to different forms of sexual assault in various degrees. And we're going to explore all these concepts in more depth. Criminologists see rape not as a sexual crime, but as a crime of violence, a coercive act of aggression. And in many countries, rape was used as a weapon of war. And there's a number of examples of that in the book. But let's talk about rape. The FBI began using a gender-neutral definition of rape in 2012. And the definition is the penetration, no matter how slight, of the vagina, anus, with any body part or object, or oral penetration by a sex organ of another person without the consent of the victim. So what's removed out of this definition is forcible. Forcible is not required. The Uniform Crime Report, as currently reported, includes cases of both rape and attempted rape. Other sexual offenses are excluded. And based on that, it estimates that 90,000 rapes are being reported each year. But according to the victimization surveys, nearly 500,000 people are victims of rape and sexual assaults. Remember our 2 points here? Why is that number so different? 2 points. One suggests that not all rapes are being reported. Recall that the UCR is what's being reported. And also, victimization survey results include other forms of sexual assault, not just rape or attempted rape. So why not being reported? Why aren't victims reporting? Victims feel it's not important. Maybe they're embarrassed. Some feel as though their own circumstances or fault put them in that situation, or that's what they may be accused of. Some feel it's not quote unquote real rape because the attacker was someone the victim knew. The crime statistics have revealed certain patterns relative to rape and sexual assault crimes. Rape is a warm weather crime, with most incidences occurring in July and August, while December, January, and February being the lowest. The urban metropolitan areas have higher rates of rape than rural. However, that is on the decline more so than in rural areas. And there is no single type of rape or rapist. Criminologists have attempted to define and categorize the vast variety of rape situations. Because there are various types of motivations for rape, there are various types of rapists. And psychologist Nicholas Groth, he's an expert and an expert in treating sex offenders, attempting to classify the personalities of rapists based on their motivation factors. And this is what he has concluded. According to Groth, every rape has at least one of these three elements: anger, power, sadism. Sadism meaning that the tendency to derive pleasure, especially sexual gratification, from inflicting pain, suffering, or humiliation on others. Their breakdown is the highest motivating factor is anger. Power is the highest motivating factor, 55%, followed by anger, 40%, sadist rapists at 5%. Let's talk about them specifically. Anger. The anger rapists, men attack, and we're talking about men. That was his study group of men. Men attack their victims in anger. Usually the attack was impulsive and involved no prior planning on the part of the offender. These assaults are usually brutal, and after the rape, the offender felt relief because he was able to relieve his anger. The power rapists do not purposely set out to harm the victims. Power rapes are generally planned. His goal is sexual conquest and only uses force that is necessary to achieve the goal. He wants control and to dominate. Rape is a way of putting personal insecurities to rest. And the sadistic or sadism is a combination of the two, anger and power motives. And these, while they're the rarest, they often involve some level of torture. In researching his findings, the conclusion is that rape is he's indicated that rape is a violent crime, not a sex act, in which the predatory criminal chooses to attack a victim. Now, like rapists, there are different categories of rape. The vast majority of, we'll start with acquaintance rape or date rape, used interchangeably. The vast majority of rapes occur when the victim and the offender have some prior relationship, although not necessarily an intimate or a familial one. Some researchers who work with rape victims have stated that acquaintance rape is the most common scenario for rapes. Among adults, acquaintance rape usually occurs within the concept of a dating relationship and is sometimes referred to, like I said, as date rape. Researchers have identified college campuses as places that typically have a high incidence of rape. Societal awareness and concern for rape on college campuses did not emerge until the 1980s. Helping to publicize the problem have been a number of high-profile rape cases on college campuses in which the victims not only went public with their experiences, but also got headlines and the covers of major publications like Time, Newsweek, and People. In 1992, the Campus Sexual Assault Victims Bill of Rights Act became law. It required campus authorities to conduct appropriate disciplinary hearings, treat sexual assault victims and defendants with respect, making their rights and legal options clear, and cooperate with them, the college, fully in exercising those rights. A great deal of research on rape in college settings has focused on identifying the unique factors of campus life that may be conducive to rape. Some researchers contend that college fraternities create a sociocultural context in which the use of coercion and sexual relations with women is normal, and in which the mechanisms to keep this pattern of behavior in check are minimal at best and absent at worst. The increased awareness of campus rape has led to the development of services and programs that assist victims of sexual violence and present information that challenges rape myths. So that is a big concern, and the most common form of rape is acquaintance rape or date rape. And with most of those, or a good majority of those, happening on college campuses. The next type of rape is spousal rape or marital rape. At common law, a man could rape his spouse. The old 17th century, by the way, theory was that by their mutual matrimonial consent and contract, the wife given up herself unto her husband. And this exception was still very much in existence in the states in this country until the 1970s, when the Rape Reform Act laws took place. Now it is a crime in every state. And the laws, the specific statutes on these laws actually downgrade the spouse rape as a separate crime, other than it being considered the same as rape against a stranger or a acquaintance rape. So it's a lower grade offense. Statutory rape, I'm working on that one. Criminalizes sexual intercourse with a victim who is under the age of consent. That age is laid out in statutes, depending on the state. New York, that age is 17 years old, even if the underage victim consented. You don't need force. Force isn't required. It's an age. There's an age component if the victim is under 17 in New York State. And to carry on a little further on statutory rape, it is what we call a strict liability crime. You can't say I didn't mean to do that, I didn't intend to do that, if the victim is under the age, and there is going to be a charge and probably a conviction. It's not a defense to say I didn't know she was 15, or she lied about her age, or she looked 21. There are some states that if she lied and manipulated the situation, I say she, the victim, then there is some defense component, but in the majority of states, that doesn't really matter. Romeo and Juliet laws only applies. This is, we don't really refer to it as that, but that's the extension. It only applies to statutory rape when both parties engage in consensual sex, so there has to be consent. The crime is actually decriminalized if the ages of the parties are within a few years of each other, such as, an 18-year-old and a 16-year-old. Remember, 17 is our technical age to be charged with statutory rape. So the suggestion is that they're a couple and they're together. So would not be considered statutory rape. There is that exception that exists. Rape by deception. Technically, the idea behind rape by deception is that there was no voluntary consent. This occurs when the rapist uses fraud or trickery to convince the victim to engage in sex. And there's two types. One is considered rape, the other one is not. I'll give you some examples because I don't think the book really fleshed it out. So you get the idea. Jane says to Tom, "I believe you should only have sex with the one you love." Tom replies, "It was love at first sight for me, Jane. I think you are the girl I will marry." Jane, moved by Tom's earnestness, and says, "Oh, Tom, I'm so glad you feel that way. Let's make love." They have intercourse, and as Tom leaves that night, he turns to Jane and says, "I don't want to see you again." Is that rape? He lied. There was some sort of fraud there, but it's not actionable. The law of rape does not criminalize obtaining sexual intimacy by this type of deception. Jane was still able to make her own decision about sexual intimacy. The seduction or manipulation is not actionable. On the flip side, a victim goes to a medical professional to undergo a procedure and learns that a sexual assault was committed against them. This is a fraud. Dr. Brown, gynecologist, is about to give his patient Heather a vaginal exam. Contrary to professional protocol, he suddenly tells his nurse to leave the exam room on the pretext of locating some test results. Pretending to put on a latex glove, Dr. Brown inserts his bare hand into Heather's vagina and touches it for his own sexual gratification rather than to conduct a proper exam. This is actionable. Rape by deception. And then our last type of rape, sex in authority relations. It's a crime for people in power to have sexual relations with those whom they have control or supervise. It's really limited state by state as to what constitutes authority relationships. In New York, prison guards over inmates, there's, a level of authority there. Adults that work in youth homes, there's an issue relative to the conduct there, even if it's consensual, because they're considered, it's not, because they're in a position of power, it's not looked upon as consensual because these individuals and victims are under their control. The book mentions patient doctor, boss subordinate, professor student. Yes, those types of relationships can be actionable as well in a different, but it has to be laid out by state statute. All right. Causes of rape. We touched on the factors that predisposes someone to violence, but what are the factors that predisposes someone to commit rape? There are several views and categories, and the focus here again is on men who commit rape. Evolutionary factors. Sexual violence is instinctual. The sexual urge corresponds to the unconscious need to preserve the species by spreading one's genes as widely as possible. Male socialization, another category. Men who have been socialized to be aggressive with women and believe that the use of violence or force is legitimate if their sexual advances are rebuffed. This is aggravated if the socialization is reinforced by peers who share similar views and values. Psychological abnormality. A traumatic childhood resulting in mental illness or personality disorder. Serial rapists and repeat offenders have exhibited psychopathic personality structures. Rape has been linked to narcissistic personality disorder, which is a mental condition in which people have an inflated sense of their own importance, a deep need for excessive attention and admiration, troubled relationships, a lack of empathy for others. But behind this mask of extreme confidence lies a fragile self-esteem that's vulnerable to the slightest criticism. An example of this, Ted Bundy. Not only was he a serial rapist, but he was a serial killer. Social learning. Rape is a learning behavior. Subject to sexual abuse, witness violence, watching violent pornographic materials, interaction with peers who articulate and support sexual violence is another cause. Gender conflict. Men who fear women as a threat due to women making progress towards social, political, and economic equality. They react through efforts of formal and informal controls over women. Informal control is to dominate women sexually through the commission of rape. The other is recognized in the male-dominant criminal justice system, where the maybe less efforts in handling rape cases are happening. Sexual motivation as the last factor that predisposes men to rape, despite the fact that rape is a violent act. Some rapists actually have sexual feelings for their victims, so they might be motivated by their sexual feelings. In a rape case, a prosecutor must prove that the victim did not consent to the sexual intercourse, and this is a controversial point. The modern view is to eliminate this element. The argument is that it forces the jury's attention to the victim's behavior rather than the defendant's behavior. It also allows a defendant to claim that they believe they had consent in almost every situation, making it hard for rapists to be convicted. Requiring the initiator of sexual conduct to obtain the unambiguous agreement of his or her partner ensures that physical intimacy is mutually desired, providing more protection to the victims. So the question is, how does a prosecutor prove lack of consent? Because that's still the case. The victim must be capable of giving consent. So when a victim is incapable of giving consent, maybe the age, a young age, they lack the capacity, being intoxicated or impaired or some incapacity by a mental defect or intellectual impairment, it might be automatic that they could not give consent. And intoxication doesn't have to be involuntary intoxication. Somebody drank too much in a party and got drunk, or somebody slipped something in a drink to cause the intoxication. Force or threat of force is needed to prove a rape case in most cases. It depends on the statute and the highest level of a charge if it's forced. Some instances, the prosecutor may show that the resistance, they resisted or they fought them off, victim. Under the common law, force or a threat of force was needed. It's not so much, some states do, for a high-level charge of rape. but most do not. New York does not require force or a threat of force. Corroboration is another problem in rape cases and proving a rape case. Under common law, the victim's testimony alone was not sufficient evidence to meet the burden of proving rape. Corroboration is something else. You need additional evidence that supports what the victim is saying, and that's clearly hard to do when you're two people in one spot unless it happens in front of a crowd or there's a video camera showing, or the evidence taken from the scene suggests otherwise. Corroboration is something else, additional evidence that supports what the victim is saying. And this concept of corroboration does not apply to other types of crimes. So let's say, for example, an assault. I'll take an assault because we're going to talk about it shortly. You claim that I punched you in the face. Luckily, you received no marks. You didn't have to go to the hospital. But I say it didn't happen, that you made it all up because you gave me a bad grade. This would be a case that they call he said, she said, right? It's one word against the other. And yes, it is hard to prove when it comes down to it. But what happens is the jury has to decide who's more credible in deciding. And yes, it is a hard case. But that is the law. No corroboration is necessary. You don't have to come up with an additional evidence to support what you're saying. But with rape, the law required more than just the victim's statement, more than a he said, she said. And critics claim that rape victims should be treated like any other crime victims and not held to this higher standard of corroborating their story. The argument on the other side is that if you lessen the burden, there's a more likelihood of, convicting an innocent person. Why is that, or how is that? Well, then there's the ease of fabrication. There's a fear of false charges. It's possible that false conviction because of, an emotional jury reaction. The difficulty of proving a charge of rape, he said, she said, is credibility, right? I mean, what if, there's a divorce going on, or separation, or a breakup? What would stop somebody from retaliating and saying that this happened when maybe it didn't happen? And as you've seen from the book, there are some examples, high-profile cases where that has been the case, where it's determined that the victim lied. However, all states have done away with the requirement with forcible rape. Showing signs of resistance is still good, and most states have done away with this corroboration requirement altogether, so it can turn on a he said, she said. The last part of the reform, the rape shield laws, until the 1970s, it was a common defense strategy to attack the character of the victim, using past sexual history and reputation, implying that women who had sex outside of marriage were immoral and therefore they're not believable. The rape shield laws passed in the 70s did away with most of that, or at least curtailed that type of attack, only allowing the victim's past sexual history with the defendant is now only allowed, and some still think that shouldn't even be the case, but that's still the requirement, at least in New York State. So only allowing the victim's past sexual history with the defendant, no other partners, and only on the issue of consent, whether she consented in the past. Court makes special rulings on these questions. And, the law can include other exclusions, like whether she asked the defendant to wear a condom. That's another issue that comes up. Well, it must be consensual since she asked to use the condom. And the rebut of that is she was protecting herself from getting, a disease. So even that information can't come in any further. These laws prevent people who file rape charges from having their privacy invaded and from being humiliated in court based on matters not relevant to their credibility or the issues in the case. So that is our look at the violent crime of rape. We're going to move on to the violent crime of homicide.